Binoibi Domingo. Facts: on September 27, 1988, Petitioner Municipality, through its council, approved Resolution Number 60, a resolution to confirm and/or ratify the ongoing burial assistance program extending P500 to a bereaved family, funds to be taken out of unappropriated available funds existing in the municipal treasury. Metro Manila Commission approved Resolution Number 60. Thereafter, the municipal secretary certified a disbursement fired of P400,000 for the implementation of the program. However, COA disapproved Resolution 60 and disallowed in audit the disbursement of funds. COA denied the petitioners reconsideration as Resolution 60 has no connection or relation between the objectives sought to be attained and the alleged public safety, general welfare, etc. of the inhabitant of Makati. Also, the resolution will only benefit a few individuals. Public funds should only be used for public purposes. Issue 1. Resolution Number 60, reenacted under Resolution Number 243, of the Municipality of Makati is a valid exercise of police power under the General Welfare Clause. Held, yes. Ratio, the police power is a governmental function, an inherent attribute of sovereignty, which was born with civilized government. It is founded largely on the maxims, Secutor tuo eta henum non latas and salus populi est supremo lex. Its fundamental purpose is securing the general welfare, comfort, and convenience of the people. Police power is inherent in the state but not in municipal corporations. Before a municipal corporation may exercise such power, there must be a valid delegation of such power by the legislature, which is the repository of the inherent powers of the state. A valid delegation of police power may arise from express delegation, or be inferred from the mere fact of the creation of the municipal corporation, and as a general rule, municipal corporations may exercise police powers within the fair intent and purpose of their creation, which are reasonably proper to give effect to the powers expressly granted. And statutes conferring powers on public corporations have been construed as empowering them to do the things essential to the enjoyment of life and desirable for the safety of the people. Municipal governments exercise this power under the General Welfare Clause. Pursuant thereto, they are clothed with authority to enact such ordinances and issue such regulations as may be necessary to carry out and discharge the responsibilities conferred upon it by law, and such as shall be necessary and proper to provide for the health, safety, comfort, and convenience, maintain peace and order, improve public morals, promote the prosperity and general welfare of the municipality and the inhabitants thereof, and ensure the protection of property therein. And under Section 7 of BP 337, every local government unit shall exercise the powers expressly granted, those necessarily implied therefrom, as well as powers necessary and proper for governance, such as to promote health and safety, enhance prosperity, improve morals, and maintain peace and order in the local government unit, and preserve the comfort and convenience of the inhabitants therein. Police power is the power to prescribe regulations to promote the health, morals, peace, education, good order, or safety and general welfare of the people. It is the most essential, insistent, and illimitable of powers. In a sense, it is the greatest and most powerful attribute of the government. The police power of a municipal corporation is broad, and has been said to be commensurate with, but not to exceed, the duty to provide for the real needs of the people in their health, safety, comfort, and convenience as consistently as may be with private rights. It extends to all the great public needs, and, in a broad sense, includes all legislation and almost every function of the municipal government. It covers a wide scope of subjects, and, while it is especially occupied with whatever affects the peace, security, health, morals, and general welfare of the community, it is not limited thereto, but is broadened to deal with conditions which exist so as to bring out of them the greatest welfare of the people by promoting public convenience or general prosperity. and to everything worthwhile for the preservation of comfort of the inhabitants of the corporation. Thus, it is deemed inadvisable to attempt to frame any definition which shall absolutely indicate the limits of police power. COA is not attuned to the changing of the times. Public purpose is not unconstitutional merely because it incidentally benefits a limited number of persons. As correctly pointed out by the Office of the Solicitor General, the drift is towards social welfare legislation geared towards state policies to provide adequate social services. The promotion of the general welfare, social justice, as well as human dignity and respect for human rights. The care for the poor is generally recognized as a public duty. The support for the poor has long been an accepted exercise of police power in the promotion of the common good. There is no violation of the Equal Protection Clause in classifying paupers as subject of legislation. Paupers may be reasonably classified. Different groups may receive varying treatment. Precious to the hearts of our legislators, down to our local councillors, is the welfare of the paupers. Thus, statutes have been passed giving rights and benefits to the disabled, emancipating the tenant farmer from the bondage of the soil, housing the urban poor, etc. Resolution number 60, reenacted under Resolution number 243, of the Municipality of Makati, is a paragon of the continuing program of our government towards social justice. The burial assistance program is a relief of pauperism, though not complete. The loss of a member of a family is a painful experience, and it is more painful for the poor to be financially burdened by such death. Resolution number 60 vivifies the very words of the late President Ramon Magsaysay: those who have less in life, should have more in law. This decision, however, must not be taken as a precedent, or as an official go signal for municipal governments to embark on a philanthropic orgy of inordinate doleouts for motives political or otherwise. City Government of Quezon City v. Ericta. Facts. Section 9 of Ordinance number 6118 requires that at least 6% of the total area of a memorial park cemetery shall be set aside for charity burial. For several years, the section of the ordinance was not enforced by city authorities, but 7 years after the enactment of the ordinance, the Quezon City Council passed the resolution directing the city engineer to stop selling memorial park lots where the owners thereof have failed to donate the required 6% space for pauper burial. Respondent reacted by filing with the CFI a petition for declaratory relief, prohibition and mandamus with preliminary injunction seeking to annul Section 9 of the ordinance in question. The respondent alleged that the same is contrary to the Constitution, the Quezon City Charter, the Local Autonomy Act, and the revised Administrative Code. The court declared the Section 9 null and void. Petitioners argue that the taking of the respondent's property is a valid and reasonable exercise of police power, and that the land is taken for a public use as it is intended for the burial ground of paupers. They further argue that the Quezon City Council is authorized under its charter, in the exercise of local police power. On the other hand, respondent contends that the taking or confiscation of property is obvious because the ordinance permanently restricts the use of the property such that it cannot be used for any reasonable purpose and deprives the owner of all beneficial use of his property. Issue 1. Section 9 of the ordinance in question, a valid exercise of the police power. Held, no ratio. An examination of the Charter of Quezon City does not reveal any provision that would justify the ordinance in question except the provision granting police power to the city. The power to regulate does not include the power to prohibit. A fortiori, the power to regulate does not include the power to confiscate. The ordinance in question not only confiscates but also prohibits the operation of a memorial park cemetery. There are 3 inherent powers of government by which the state interferes with the property rights, namely police power, eminent domain, taxation. These are said to exist independently of the Constitution as necessary attributes of sovereignty. Police power is defined by Freud as the power of promoting the public welfare by restraining and regulating the use of liberty and property. It is usually exerted in order to merely regulate the use and enjoyment of property of the owner. If he is deprived of his property outright, it is not taken for public use but rather to destroy in order to promote the general welfare. In police power, the owner does not recover from the government for injury sustained in consequence thereof. The police power being the most active power of the government and the due process clause being the broadest station on governmental power. The conflict between this power of government and the due process clause of the Constitution is oftentimes inevitable. It will be seen from the foregoing authorities that police power is usually exercised in the form of mere regulation or restriction in the use of liberty or property for the promotion of the general welfare. It does not involve the taking or confiscation of property with the exception of a few cases where there is a necessity to confiscate private property in order to destroy it for the purpose of protecting the peace and order and of promoting the general welfare, as for instance, the confiscation of an illegally possessed article, such as opium and firearms. It seems to the court that Section 9 of Ordinance No. 6118, Series of 1964 of Quezon City is not a mere police regulation but an outright confiscation. It deprives a person of his private property without due process of law, nay, even without compensation. There is no reasonable relation between the setting aside of at least 6% of the total area of an private cemeteries for charity burial grounds of deceased paupers and the promotion of health, morals, good order, safety, or the general welfare of the people. The ordinance is actually a taking without compensation of a certain area from a private cemetery to benefit paupers who are charges of the municipal corporation. Instead of building or maintaining a public cemetery for this purpose, the city passes the burden to private cemeteries. The expropriation without compensation of a portion of private cemeteries is not covered by Section 12 of the revised Charter of Quezon City, which empowers the City Council to prohibit the burial of the dead within the center of population of the city and to provide for their burial in a proper place subject to the provisions of general law regulating burial grounds and cemeteries. When the Local Government Code, Batas Pambansa BLG 337 provides in Section 177 that a Sangguniang Panlungsod may provide for the burial of the dead in such place and in such manner as prescribed by law or ordinance, it simply authorizes the city to provide its own city-owned land or to buy or expropriate private properties to construct public cemeteries. This has been the law and practice in the past. It continues to the present. Expropriation, however, requires payment of just compensation. The questioned ordinance is different from laws and regulations requiring owners of subdivisions to set aside certain areas for streets, parks, playgrounds, and other public facilities from the land they sell to buyers of subdivision lots. The necessities of public safety, health, and convenience are very clear from said requirements, which are intended to ensure the development of communities with salubrious and wholesome environments. The beneficiaries of the regulation, in turn, are made to pay by the subdivision developer when individual lots are sold to homeowners. As a matter of fact, the petitioners rely solely on the General Welfare Clause or on implied powers of the municipal corporation, not on any express provision of law as statutory basis of their exercise of power. The clause has always received broad and liberal interpretation, but we cannot stretch it to cover this particular taking. Moreover, the questioned ordinance was passed after Himlayang Pilipino, Inc. had incorporated, received necessary licenses and permits and commenced operating. The sequestration of 6% of the cemetery cannot even be considered as having been impliedly acknowledged by the private respondent when it accepted the permits to commence operations.